Hi, I am attorney Chris Bathan-lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, I shall aim to simplify the law. I will discuss concepts and principles of law in under 10 minutes.
Hello again, everyone. This video lecture, I want to talk about the marriage license because, as we said, that's one of the formal requisites to make your marriage valid. As I have mentioned in the previous video lecture, we apply for the marriage license before the local civil registrar of the city or municipality where either of the parties reside. So, how do we go about applying for a marriage license? So, we go to the local civil registrar of the city or municipality where either of you or your partner reside. And then we are being asked to fill out a form. It is a sworn application form. And what are the information required? You will see that under Article 11. Article 11 says, where a marriage license is required, each of the contracting parties shall file separately a sworn application for such license with the proper local civil registrar, which shall specify the following. Number 1, full name of the contracting party. 2, place of birth. 3, age and date of birth. 4, civil status. 5, if previously married, how, when, and where the previous marriage was dissolved or annulled. 6, present residence and citizenship. 7, degree of relationship of the contracting parties. 8, full name, residence, and citizenship of the father. 9, full name, residence, and citizenship of the mother. And 10, full name, residence, and citizenship of the guardian or person having charge in case the contracting party has neither father nor mother and is under the age of 21 years. The applicants, their parents or guardians, shall not be required to exhibit their residence certificates in any formality in connection with the securing of the marriage license. Now, once you fill out the sworn application form containing all those information, is that it? Do we now get a marriage license? No. There are still requirements or documents that we have to submit. What are these? Number 1, you have to submit a birth certificate. What's the purpose of the birth certificate? That is for the local civil registrar to ascertain your age, because we said you have to be at least 18 years of age to marry. So when you apply for a marriage license, you must be at least 18 years of age. Now, what happens if you don't have a birth certificate? Your parents may have failed to register your birth. Is there a remedy for that? What may you present? In the absence of a birth certificate, you may present a baptismal certificate. If you still don't have that, you may present a residence certificate. If you still don't have that, then you may submit a joint affidavit signed by the two nearest of kin attesting that you are of legal age. Now, are there instances where a birth certificate, the submission rather of the birth certificate may be dispensed with? Yes, there are times that it may be dispensed with, or your local civil registrar may not require submission of the birth certificate. When are these? First, if the parents of the contracting parties personally appear before the local civil registrar and attest to the age of the contracting parties. You actually can find that under Article 12. That's the first instance where you may not need to submit anymore the birth certificate. Second is when the local civil registrar, just by merely looking at the contracting parties who are rather personally appearing before him or her, the local civil registrar is convinced that they are of legal age. In other words, face value. By looking at them, he is already convinced that they are of legal age. That's the second instance. The third instance where you may no longer be required to submit your birth certificate is when you have already been previously married, but of course the marriage has already been declared null and void or has been annulled. But this time, since you're not required to submit your birth certificate, you will be required to submit the order or judgment of the court declaring your marriage null and void or annulling your marriage. Those are actually under Articles 12 and 13 of your family code. Those papers or documents that are required to be submitted. Those that I have just discussed. Now, is there anything else that you need to submit apart from all of those that we have just mentioned? Yes, there still is. That is, if the contracting parties, or at least one of them, are between the ages of 18 to 25. What else is required? The law says, in case either or both of the contracting parties not having been emancipated by a previous marriage are between the ages of 18 and 21, they shall, in addition to the requirements of the preceding articles, exhibit to the local civil registrar the consent to their marriage of their father, mother, surviving parent or guardian, or persons having legal charge of them in the order mentioned. Such consent shall be manifested in writing by the interested party who personally appears before the proper local civil registrar, or in the form of an affidavit made in the presence of two witnesses and attested before any official authorized by law to administer oaths. The personal manifestation shall be recorded in both applications for marriage license, and the affidavit, if one is executed instead, shall be attached to said applications. That is Article 14, requiring the submission of parental consent for those marrying, according to Article 14, between the ages of 18 and 21. Now, let's look at Article 15, which also requires parental advice between the ages of 21 and 25. Article 15 says, any contracting party between the age of 21 and 25 shall be obliged to ask their parents or guardian for advice upon the intended marriage. If they do not obtain such advice, or if it be unfavorable, the marriage license shall not be issued till after 3 months following the completion of the publication of the application. Therefore, a sworn statement by the contracting parties to the effect that such advice has been sought, together with a written advice given, if any, shall be attached to the application for marriage license. Should the parents or guardian refuse to give any advice, this fact shall be stated in the sworn statement. So now, you have Article 14 saying that parental consent is needed between the ages of 18 and 21. And then, parental advice is needed between 21 and 25. Now, how about if the age is exactly 21? Is it parental advice or parental consent that is required? Now, we have to interpret it by also looking at the other articles in the family code. The better interpretation for Article 14 and 15 is that parental consent is required for ages between 18 to below 21, while parental advice is needed for ages between 21 to 25. Now, why do I say that it should be interpreted that way? Because you have to look at Article 45, Paragraph 1, which says that a marriage may be annulled for any of the following causes. And Paragraph 1 says that the party on whose behalf it is sought to have the marriage annulled was 18 years of age or over but below 21, and the marriage was solemnized without the consent of the parents. That tells us that the parental consent really was intended for those ages 18 to below 21. So to avoid confusion between Article 14 and 15, we look at Article 45, Paragraph 1. So again, for parental consent, that is needed for ages 18 to below 21, and parental advice is needed for ages 21 to 25. So is there anything else needed apart from parental consent and parental advice? There still is. The law says that if either of the contracting parties would be required to submit parental consent or parental advice, then they also need to submit a certificate of marriage counseling. What is this? That's under Article 16. It says, in the cases where parental consent or parental advice is needed, the party or parties concerned shall, in addition to the requirements of the preceding articles, attach a certificate issued by a priest, imam, or minister authorized to solemnize marriage under Article 7 of this code, or a marriage counselor duly accredited by the proper government agency to the effect that the contracting parties have undergone marriage counseling. Failure to attach said certificates of marriage counseling shall suspend the issuance of the marriage license for a period of 3 months from the completion of the publication of the application. Issuance of the marriage license within the prohibited period shall subject the issuing officer to administrative sanctions but shall not affect the validity of the marriage. Should only one of the contracting parties need parental consent or parental advice, the other party must be present at the counseling referred to in the preceding paragraph. That means that even if only one party is required to submit parental advice or parental consent, the other must still be present at the marriage counseling. So for example, if there's a marriage between someone who is 23 years old and 28 years old, the 23-year-old is required parental advice and marriage counseling. Just because his or her partner is 28 is no longer covered by parental consent or parental advice, he or she cannot excuse himself from the marriage counseling. It's called marriage counseling, not just counseling. So they have to both be there. So they have to submit that as well. Now remember, Article 15 and 16 also made mention that if the parties cannot submit parental advice or the certificate of marriage counseling, it will actually not stop the issuance of the marriage license. The issuance will just be suspended for 3 months, perhaps to give them time to procure or to get that parental advice or to go into marriage counseling, or at least they could still think about it. So once you have filled out the form, you have submitted all the requirements for you to get a marriage license, what happens next? What does the local civil registrar do? The LCR, or your local civil registrar, will post the application. There's now the posting that's under Article 17. It says the local civil registrar shall prepare a notice which shall contain the full names and residences of the applicants for a marriage license and other data given in the applications. The notice shall be posted for 10 consecutive days on a bulletin board outside the office of the local civil registrar, located in a conspicuous place within the building and accessible to the general public. This notice shall request all persons having knowledge of any impediment to the marriage to advise the local civil registrar thereof. The marriage license shall be issued after the completion of the period of publication. So, when you apply for a marriage license before it is issued, it is posted by your LCR. And the purpose of the posting is to invite everyone who may know of any impediment of the marriage between these two parties who would want to marry each other. Now, what happens if someone reports an impediment? What if someone says, hey, the woman who intends to marry this man is actually already married. What now happens if there is an impediment that is being brought to the local civil registrar? Will the LCR now stop the issuance of the license? The answer is no. Article 18 of the Family Code answers the question. It says, in case of any impediment known to the local civil registrar or brought to his attention, he shall note down the particulars thereof and his findings thereon in the application for marriage license, but shall nonetheless issue said license after the completion of the period of publication, unless ordered otherwise by a competent court at his own instance or that of any interested party. No filing fee shall be charged for the petition, nor a corresponding bond required for the issuances of the order. That tells you that even if the LCR himself knows of an impediment or somebody reports to him an impediment, he cannot stop himself from issuing the license. The only way for him to stop himself from issuing the license is when there is a court order. So either he petitions an injunction before the court to stop him from issuing, or another interested party will request or ask the court to stop the LCR from issuing the license. Without that court order, the LCR cannot stop issuing the license. The reason behind that is to avoid extortion. Now, once everything is completed, you have complied with everything, the publication is also already done, the 10-day publication is completed, the LCR now issues the license. As I've mentioned previously, the marriage license has an effectivity period of 120 days. So you have to use it within 120 days because after that, it expires automatically. Now, where can you use it? You can use it anywhere in the Philippines. So even if you have obtained it in Cebu City, you can use it in Makati, you can use it in Quezon City. If you got it in Makati City, you can use it in Mandaue City, in Lapu-Lapu City. You can use it anywhere in the Philippines so long as the marriage license is still valid and effective. That is it for your marriage license. So I hope you have learned something from this video, and I will see you in the next.
If you find this video helpful, please click like, subscribe, and that notification bell so that you will be notified of new video uploads. Thank you for watching. See you next time in MBL Classroom.